Well, at its basic, the UK is a common law jurisdiction, which means it has a body of law based on court decisions that run alongside statutory law. As it pertains to trademarks, it is true that UK common law can share or have some similarities with elements of unfair competition law abroad. But again, UK common law in this sense is still quite a different beast altogether. It is incredibly flexible and can be moulded case by the courts, allowing it to develop and apply to new or very, very specific different facts to each case. There are no regulations, no article numbers to follow. It is always based on facts, and it naturally evolves. So from Gyp Lemon all the way since 1990, this has stood. We can therefore state that there exists and there is a classical trinity, and that is key to establishing, succeeding with a claim under the tort of passing off. Second, goodwill is a bit like you're probably used to seeing the term and comfortable with genuine use. And that's very true. So it needs to be more than token, being a form of genuine commercial activity is generally the case law wording. But evidence is key here, and a lot of evidence. To move on to other torts in the common law that need to be considered in enforcement, these are very, very broad areas in themselves. So for now, I'm going to discuss them as things to consider for UK enforcement as an overview. I'm also going to mention threats a couple of times in the next few slides, and I'll put that into context later. But for now, statutory infringement, Section 10 of the UK Trademarks Act 1994. Within that act, there is also Section 21, which deals with threats. And it basically means that if a threat is made against you, you can counter-sue, you can counter-claim for unjustified threats. And these are very real. They're very expensive, they're very stressful, and you can't just write to people saying you've got a registered trademark and you're going to force them to demand cease and desist and demand undertakings and threaten everything in the world